that vast, larger sum numbers of people were stopped from getting married, namely people from between different castes or within the Gotra, the Sagotra marriages were prohibited. So technically, or indeed, as I said, the US, where a black man and a white woman couldn't get married. There were anti-miscegenation laws. So there was this social institution which existed, but people were arbitrarily excluded from that social institution as because of their innate characteristics, race, caste, subcaste, etc.
The creation of an institution or recognition of an institution is being discussed. We don't wish to highlight the fact that all the material placed by both parties before the court clearly reveal that when the law was being framed, even in the context of the Special Marriage Act, which is meant to facilitate the very same intercaste and interfaith marriages, it was very clearly heterosexual in nature. Therefore, when the question was put to the other side, do you have any material to show that there was any kind of elasticity that was meant to be read into any of these provisions? They did not have an answer.
Is that a question of gender and sexuality is very similar to caste. Just as you cannot block access to the privileges, rights that a straight couple has by virtue of their gender and their sex, that same privilege must also be extended to everybody, regardless and irrespective of their sexuality.
Please tell us, how do you wish to apply the Domestic Violence Act in the context of same-sex marriages? How do you wish us to interpret these provisions? When these very clear questions came from the court, practical operational issues, because I am not necessarily throwing around the bogey of 600 laws to say, let's stop this. These are very clear issues because there are welfare legislations and protective legislations that have come into existence to protect a particular gender.
Why have the Supreme Court? Let's just have Mufassil courts, because they'll get it right the first time. We recognize they don't get it right, which is why there is appellate provisions. There is a doctrine of overruling, because no one, save God, is always right.
The question is, how are you going to identify this in the context of these kind of marriages? These are very real questions. We are not in the realm of speculation here.
I assure you, I don't take offense so seriously. Anyone who's grown up gay for 50 years doesn't take offense seriously. Right? We're used to a lot worse, and you, and my friend, are not a bad man. At least that's it. No matter what. So the question is, the argument is that courts are being asked to create a social institution when they do not have the expertise or the power to do so. Well, I'm afraid that's simply not true, because that social institution of marriage already exists. A vast majority of you are married. I'm not saying create a concept which does not exist. What we are saying is, here is a social institution which, as you said, amends 600 laws, because 600 laws exist to give a right to that particular social institution. Please extend the same protection of the laws, of those 600 laws which are good enough for straight people. Please extend the same social institution to those who are otherwise, in any case, disempowered. Now, I take an example about how this is not a creation of a social institution. I draw the memory of your audience into what happened in the US in the 60s and what used to happen in certain parts of India. That certain groups of people were not permitted to get married. Not just brothers and sisters. Those are interesting examples and make for good debating points. But the reality is that vast, larger numbers of people were stopped from getting married, namely people from between different castes or within the Gotra, as the Sagotra marriages were prohibited, right? So technically, or indeed, as I said, the US, where a black man and a white woman couldn't get married. There were anti-miscegenation laws. So there was this social institution which existed, but people were arbitrarily excluded from that social institutions as because of their innate characteristics, race, caste, subcaste, etc. Now, each of these, I think we would agree that courts were right to step in and say, no, you cannot stop people from a different caste from getting married, and would intervene and say this social institution, people of all castes should have access to. Now, what our argument in court is that a question of gender and sexuality is very similar to caste. Just as you cannot block access to the privileges, rights that a straight couple has by virtue of their gender and their sex, that same privilege must also be extended to everybody, regardless and irrespective of their sexuality. So that's the argument. It's not the creation of an institution. I certainly am not one of those people who again, prioritizes or fetishizes the court over every other institution. I don't think the courts get it right every time. Very often they don't. That is why they provide for appeals. If the idea is the judge is always right, there is no question of having a hierarchy of courts. Why have the Supreme Court? Let's just have Mufassil courts, because they'll get it right the first time. We recognize they don't get it right, which is why there is appellate provisions. There is a doctrine of overruling, because no one, save God, is always right. So once we accept that fact, that argument is not being made by me or indeed anyone else, that the courts always get it right. It is a question of institutional competence and power. And that's correct. I would say that in matters of fundamental rights, where the very dignity of a person is involved, when the identity of a person says, I can no longer get married because my nation abhors me and does not permit me to live freely, openly, and joyously with the person I love, that frames their own sense of self, that touches their fundamental right, their idea of their own existence. And in matters which are so fundamental and personal, the courts don't have merely the right to step in, they have the obligation to step in. Right?
You're right?
So, I want to, unless you're going to make a radically different point, because we are kind of circling.
Just one point. It's indeed surprising that when the question of whether it's the creation of an institution or recognition of an institution is being discussed, we don't wish to highlight the fact that all the material placed by both parties before the court clearly reveal that when the law was being framed, even in the context of the Special Marriage Act, which was meant to facilitate the very same intercaste and interfaith marriages, it was very clearly heterosexual in nature. Therefore, when the question was put to the other side, do you have any material to show that there was any kind of elasticity that was meant to be read into any of these provisions? They did not have an answer. The second question the court specifically asked was this: please tell us, how do you wish to apply the Domestic Violence Act in the context of same-sex marriages? How do you wish us to interpret these provisions? When these very clear questions came from the court, practical operational issues, because I'm not necessarily throwing around the bogey of 600 laws to say, let's stop this. These are very clear issues because there are welfare legislations and protective legislations that have come into existence to protect a particular gender. The question is, how are you going to identify this in the context of these kind of marriages? These are very real questions. We are not in the realm of speculation here.
So, Sai, just to keep the audience with us, here's and I'm just using the moderator's prerogative to cut you off here, Saurabh, to say that a lot of this will evolve. None of the laws that we've had 60 amendments and more of the Constitution, and a lot of things keep evolving as society changes, Let's go back to dowry, widow remarriage, child marriage, property rights, even women's right to their parental and ancestral property changed as recently as 2005.
Through legislature or judiciary?
Through legislature.
Thank you.
But I'm saying that things keep changing and evolving. So let's not get into the practicalities of this right now. Let's stick with the principles. I want to bring in a few more because, we're going over the same argument. Do they have right? And it's a fundamental right. Just a couple of points. You've been saying that there is the space for cultural conservatism and that it should have a space in society. And if we're going to say that the Constitution is a liberal document, how are conservative people going to express themselves and what are their rights? So here I'd like to ask you this question, that where would you draw the line on conservatism? If the Khap Panchayat doesn't want women to go to work or to have a gungat, and don't call me a liberal because I've sat in a train full of 6,000 Muslim clerics and asked them, why will they speak with a woman who's not a Muslim, but there's not one other woman in that train that was a peace train going from Deoband to Hyderabad. So I don't think that there's anything frozen about the Muslim community or the Hindus. I'm just asking you, when there's all these slippery slides of cultural conservatism, which conservatism do you want should be the arbiter of whether we eat, love, pray, what we wear? The government very often says that they want to define that.
Is your visual image of conservatism going to limit itself only to Khap Panchayats? Are you saying that there are no other shades of conservatism which are sophisticated?
No, many. Like a father, there are many.
No, I felt that the example was perhaps it was stereotypical.
No, I was just evoking the easiest shorthand.
So that's the problem with the shorthand because then it loses nuance. The point I'm trying to make is this. I am not on the question of whether conservatives must have the right to draw a line. The question was entirely in my submission, you can play it out for everybody's benefit, was, do people holding a conservative point of view not have a seat at the table when this issue is being discussed? Are they not participants to this particular discussion in any way? They can be wrong. They can be 100% wrong. But are you going to deny them the right to participate in this discussion by having this closed-door hearing, so to speak? Because it is a closed-door hearing when the rest of the society doesn't get to participate in it. You cannot compare the scale of this particular discussion or its comprehensive nature or lack of comprehensiveness, so to speak, with what happens in the legislature. So the point is entirely this. I don't think that the conservatives must effectively have the power of veto. That's not been my position. But they certainly have the right to participate in those conversations. And this forum and the nature of this proceeding does not lend itself to multi-party stakeholdership representation, thanks to the nature of the forum. It's not on this particular issue alone, on several other issues. So I'm not going to sit and say, this should be the line that conservatives must draw. Did you see me ventilate that particular position in court? No. Because I don't need to make that particular argument. The entire argument was, give us a seat at the table. Don't make this an elitist conversation where we have absolutely no space whatsoever. That's been the nature of the discussion. That's been the ask. So why do we need to actually look down upon the conservative position?
May I ask you a question here?
Please.
Saurabh, how would you respond to?
Well, that argument, if stretched to its logical conclusion, would require us to erase courts from our constitution altogether. Because every time courts decide something, for instance, in a matter of fundamental right of free speech, right? It's not as though they're deciding that it's valuable free speech or not, that they'll conduct public poll surveys and then take a decision. They're obviously not. So if every time the courts are supposed to give everybody a seat at the table, so to say, then they will never decide a case, because that's not how a judgment is made, right? There are two parties before the court, and very simply, someone as competent as I is also free to come and put the conservative point in court. That happened, right? We heard the government making arguments which were against the liberal position put forward by the petitioners. So who was silenced? The problem is not that the conservative voice was silenced. The problem was, where was the conservative voice meant to be heard? And I don't believe that there is no place for a conservative voice any more than there is no place for a liberal voice. In a free democracy, in a free country, there is a place for every stream of thought, including on this particular podium. The question, however, is that when you say that because there is a lack of hearing with the conservative voice, to me sounds really, if you unplug it enough, argument against the court exercising its jurisdiction in favor of the liberal point of view, right? That's the sum and substance, really, if you unpack the argument. Because how was the conservative position not given a seat at the table, or how was the liberal position given a greater seat at the table? Yeah. Judges are deciding, right? The judges are deciding between left and right, between conservatism and liberalism. Both sides are heard. So if you say the conservatives have no place, well, equally the liberals have no place as well. That's not what happened in court.